Well, that is service. Thank you, Mr. Chairman and members. I appreciate that. So election law, rules, and procedures should be consistent across the state, which is why during the 87th legislature, there was a statute passed that prohibited any election official from being able to alter election laws, rules, or procedures not explicitly allowed by the Texas Election Code. However, because there is no penalty attached to this prohibition, there are still those who continue to violate this provision. So you've heard before, you know, a law without a penalty is only a suggestion. I think that may apply here. Senate Bill 618 seeks to establish civil penalties for election officials who failed to conduct their elections according to Texas Elections Code after being advised by the Secretary of State on how to correct the violation. So we're not trying to pull gotchas on anybody. The committee substitute, I do have a committee substitute, and here's what it does.
Senator Hall sends up the committee substitute and recognize Senator Sparks to explain the substitute. Go ahead.
Thank you, Mr. Chairman. The committee substitute adds some accountability measures for the Secretary of State by requiring them to post information containing each reported violation and how that violation was resolved. Under the same provision, they must also report and post any violation of which the Secretary of State is accused, thereby ensuring this authority is not abused. We have a few folks to add some clarity on this, but with that, I'm happy to try and answer any questions.
Thank you, Senator Sparks. Committee members, any questions for the author? Very well, we'll hear from the witnesses. Thanks very much. We'll open testimony on Senate Bill 618. The chair calls Marcia Strickler, Dr. Laura Presley, Debbie Lindstrom. Welcome. We'll start over here on my left. You're right, Ms. Strickler. Introduce yourself and go ahead.
Hello, my name is Marcia Strickler Watson, Williamson County. The laws that make up the Texas Election Code are merely suggestions if breaking them has no consequences. It is imperative that our election laws have sharp teeth to ensure accuracy, transparency, and most importantly, accountability. We must add more civil and criminal penalties and enhance the ones already on the books to deter negligence and criminal behavior. Texas has some of the strongest election code laws in the country. The problem is citizens have no avenue to hold election officials accountable to these laws. SB618 would put civil penalty teeth to protect our laws from being changed or altered, modified, waived, or suspended. This would include election administrators, election judges, and even the Secretary of State. Why have laws if they can simply be waived? Historically, the Secretary of State, an appointed bureaucrat, has waived, modified, suspended laws that you senators have worked hard to pass. This has got to stop. I will provide you with a few recent examples in Williamson County. On Saturday, November 9th, 2024, Williamson County Election Department began a partial manual recount of the November 24th election without giving notice to citizens and candidate representatives to observe the cutting of seals and opening of ballot boxes. Fast forward on Thursday, November 14th, Mr. Paul Parker, a candidate representative for a school board candidate, arrived at the election department at 10:30 a.m. to witness the partial manual recount process. Paul was denied entry by the election administrator, which is a violation of Texas Election Code 127.201C, failure to post notice of date, hour, and place, TEC, and failure to admit candidate representative, TEC 127.201D. Another example regarding voter rolls. Last summer, again, a group with Paul Parker submitted 5 affidavits based on personal knowledge challenging Williamson County voters who have moved or had registration addresses that were illegal or missing information. Places that used addresses with mail stores or RV parks. Volunteers put in over 100 hours door knocking to verify these moves. Only one affidavit was acted on, affecting 57 voters. The subsequent affidavits were not acted on, resulting in 4,038 voters with active status remaining active, as opposed to being placed in suspense as required by Texas Election Code 16.092. As a result, many people voted in the wrong precincts, wrong locations, wrong ballots. Again, December 2nd, a PIA number 1204-1800 was submitted requesting access to a single ballot style for review. On Friday, March 21st of this year, a response was received from the Williamson County Attorney that requests have been denied in its entirety. This is a violation of Texas Election Code 1.012E through H. Many Williamson County citizens, including myself, have submitted many sworn affidavits over the past 3 years to our county judge and commissioners court who oversee our county elections. There has been no action or response to anyone submitting those affidavits. There are currently no teeth in our laws. We have no recourse. Other affidavits filed in Williamson County are related to poll watchers being obstructed from seeing results tapes, voters receiving incorrect ballot styles, poll judges complaining that the polling location is not secured, vote flipping, exceeding the certified allowable failure rate of 1 in 125,000, TEC 122.001, that says election systems must be accurate. The secrecy of our ballot due to countywide polling programs, chain of custody violations, and spoiled ballots not following proper procedures. After many reported election violations during 2020 November general election in Williamson County, such as precinct-level barcode data glitches and many voters reporting receiving incorrect ballot styles, our team worked hundreds of hours to investigate these issues and to ask me questions and I'll finish my discussion. You have a report there from the grand jury that just came out last week.
And thanks for your testimony. Welcome. Introduce yourself. Go ahead.
Chairman Hughes and distinguished members of the committee, thank you for the opportunity to testify today. My name is Debbie Lindstrom, and I'm the Texas Elections Director for Citizens Defending Freedom, and I strongly support SB618. The Texas Constitution mandates in Article 6, Section 4, that the legislature shall make regulations necessary to detect and punish fraud and preserve the purity of the ballot box. Article 6, Section 2 further requires that suffrage shall be protected by laws prohibiting all undue influence in election from power. Punishing election crimes is not merely a legislative option, but a constitutional obligation, and a law without penalties is just a suggestion. Section 276.019 of the Election Code prohibits unlawful altering of election procedures, but lacks any enforcement mechanisms. CDF has heard from citizens all across Texas about numerous instances where election officials have altered or suspended election code. For brevity, I will just give you one example and leave you with a 45-page report with many examples of violations. CDF has conducted an extensive investigation of the chain of custody of unused ballots in Collin County over the past 4 years and discovered major discrepancies. The reconciliation of ballots is required by law, TEC 65.013. Despite the Secretary of State admonishing the county to do better, November 2024 saw over 17,000 unused Election Day ballots with no chain of custody, one of the worst discrepancies we have seen to date. Such violations create inconsistent election administration, complicate verification, and undermine public confidence. SB 618 would transform the existing violations into an enforceable mandate through a structured process that provides an enforcement mechanism and graduated penalties. In addition, the substitution language adds a public transparency provision for complaints and accountability for the SOS office. I personally consulted with both the Secretary of State's office and the Attorney General's office, and neither expressed concerns about the proposed substitution language. Some may have concerns that establishing penalties for election law violations may discourage citizens from serving as poll workers or election officials. The argument fundamentally misunderstands both the nature of the proposed penalties and the character of those who serve our electoral system. First, SB 618 is carefully structured to focus on willful violations, not good faith mistakes or technical errors. The bill includes a process for notification and the opportunity to correct before penalties are imposed. This graduated approach ensures that well-meaning officials who make inadvertent errors have the chance to rectify them without consequence. Second, the vast majority of election workers and officials are dedicated public servants who aim to follow the law precisely. It is unfair to suggest that election workers would be unwilling to serve if they cannot violate the law with impunity. Finally, the argument that we must choose between having election workers and having election integrity creates a false dichotomy that undermines our republic's principles. Texas voters deserve both adequate staffing and proper adherence to election laws. Election integrity shouldn't be a partisan issue. This bill applies equally to all jurisdictions and includes multiple safeguards against arbitrary enforcement. The notification requirements, public reporting, and judicial review options ensure transparency and equal application across political and geographic boundaries. SB 618 applies the same standards to everyone, protecting Texans' votes through consistent application of election laws. By codifying enforcement procedures, we're reducing the risk of selective enforcement while creating a level playing field that benefits candidates and voters from every political perspective. I strongly urge this committee to support SB 618 to strengthen public trust in Texas elections and protect the legislative intent of our election laws. With that, I'm happy to answer any questions the committee may have regarding this important legislation. Thank you.
And thank you for your testimony. Dr. Presley, welcome. Introduce yourself. Go ahead.
Yes, sir. Thank you, Senator Hughes, Chair Hughes, and members of the Senate State Affairs Committee. I'm Dr. Laura Presley, and I'm testifying on behalf of True Texas Elections in support of Senate Bill 618. And we're going to give you some handouts here. This bill is near and dear to my heart. It's something I've worked on for over a decade. Waivers of law by election officials. And this is such an important bill. I'd like to start my testimony with a blessing that we bless all of us that we have today in this hearing and moving forward on this bill, the mind of Christ. That we have discernment and wisdom and courage to make righteous decisions and implement laws resulting in true weights and true measures in our elections. For the law is ideal if it is used lawfully. And foremost, we need righteous laws so that we can lead quiet and peaceable lives in all goodness and reverence. And this is the hope and intent of my testimony today. With regard to my professional background, I hold a PhD in physical chemistry from UT Austin and worked in the semiconductor industry for over 17 years. And I was a senior device engineering manager, and I've led teams of engineers in the U.S., globally, in China, Malaysia, Japan, France, and Ireland. I'm a published author of peer-reviewed technical papers in physics, chemistry, and semiconductor device engineering, and I hold 4 U.S. patents in semiconductor device technology. With respect to elections, I've been a candidate, an election watcher, and statistical analyst. In 2018, I founded True Texas Elections and have trained more than 1,200 election poll watchers, central counting station watchers, recount watchers in more than 45 counties. I personally have been an election watcher in Travis and Williamson County, and I've been a recount watcher in more than 15 counties around the state. I've been a plaintiff in election cases, and I've been a testifying and consulting expert in multiple election-related contests and lawsuits. As a candidate, watcher, analyst, and trainer, I have debriefed watchers, and I've witnessed some 27 very serious election law waivers and misinterpretations provided by the Secretary of State, their election division. And they've provided these misinterpretations, in my opinion, what I believe to be based on improper legal grounds. These 27 laws that have been waived were instituted by this committee to detect and punish election fraud. I'm not talking about, well, we just opened the polls late 20 minutes. We're not talking about something that simple. These 27 laws are the most critical in our election code. They provide for and enable candidates, voters, and election officials to detect and prevent fraud. Over the last decade, I have attempted to try to address these waivers with the Secretary of State's office. I've worked with the Secretary of State's election division and county election officials. This body, to address reports from entities outside of these walls, you have gotten reports over the years about these waivers, and this legislative body in the last several years passed 4 new sections of the election code, and those new sections strictly prohibit waivers of law by the Secretary of State, but the waivers have not ceased, and that's why we're here today with this bill. True Texas Elections compiled the 27 election code waivers by the Secretary of State's division, and those have been provided to you. This was given to the Secretary of State in 2023, Ms. Jane Nelson and Ms. Atkins. I met personally with them, provided them this, and repeatedly followed up with only a few of the recount waivers being addressed. The worst of the 13 waivers in this list, and they're red on this front page, are the subject of a 2024 federal lawsuit, Presley versus Nelson, which cites the waivers are violations of the First and 14th Amendments of the U.S. Constitution, and we are in federal court right now, and you have that complaint in your packet. It's 74 pages. The consequences of violating these 13 laws have been very severe. The waivers caused the breaching of ballot secrecy for more than 6,000 in-person voters. You have that, the latest brief that was filed in that case right here. You have that. The court case is pending. We're waiting on the court to give direction before we start depositions. There's one thing I want to say, Senator Hughes, I have an amendment proposal they're in blue, and this came from a really very powerful lawyer that I work with, and we're recommending that the parties be engaged in a mediation before any legal action takes place, that the bill would add a requirement for mediation of the parties, and that would try to short-circuit a legal proceeding. And I just want to plant that seed. I want y'all to consider that, because if we could short-circuit this stuff before filing lawsuits, that's what everybody wants. So I want to plant that seed.
And thank you for your testimony, Dr.
Bless
Presley.
y'all. Thank you.
Senators, any questions for the witnesses on this bill? Very well. Thank you each for your testimony. Thank you for being here. We'll open public testimony on Senate Bill 618, and the chair calls Judge Shepard, Ken Moore, Terry Putnam, Dennis London, Sheila Hemphill. Again, on Senate Bill 618, call Judge Shepard, Ken Moore, Terry Putnam, Dennis London, Sheila Hemphill. Call Ed Johnson. Ed Johnson, James Keller. James Keller. Ms. Keller, if you're ready, we'll start with you. Since you're on the end, you got to get close to the microphone, introduce yourself, and go ahead.
I'm James Keller, a resident of Hayes County. I'm here in support of 618 with its substitution amendments or changes. We were so excited when the omnibus election bill passed a few years ago, although there was a continuation of a problem that was beforehand, which was just the ignoring of the laws. And I'm going to give you one example that was particularly astonishing to me. The new law required that the results tapes, that is, the zero tapes, that is to say the results prior to the beginning of the election, which of course should be all zeros because no votes have been cast. And that the new law said that these results tapes had to be printed immediately preceding the opening of the polls. Well, the then director of elections gave an opinion that immediately preceding means up to 4 days prior to the opening of the polls. Now, I'm reminded of my high school study of government checks and balances and the clear boundaries embodied by both U.S. and Texas constitutions which separate the roles of the executive, legislative, and judicial branches. Imagine my surprise over 10 years ago to discover that our Secretary of State and Director of Elections were apparently not aware that they were only to carry out the laws, not to write them. But apparently they were aware that as written, our election laws have few teeth. While the altering of election records carries criminal penalties, advising counties to ignore law, for instance, by refraining from creating the same records in the first place, records which are protected by law because they're necessary to make our elections auditable and credible. It is a serious offense with serious consequences to our state and to our voters. The offense of waiving law is awaiting a meaningful deterrence, and I support this bill. Thank you.
Thank you for your testimony. Welcome. Introduce yourself. Go ahead.
Good afternoon, Chairman Hughes and esteemed members of this committee. My name is Judge Shepard, and I am a policy analyst at the Texas Public Policy Foundation. Just for a little bit of the sake of clarity, I think there was confusion earlier. Judge is my name. That is not a title. However, I will say SB618 provides a civil penalty for a public or election official who violates any election standard, practice, or procedure mandated by law or rule. Free and fair elections are the goal for the state of Texas, and we do believe that this bill is a first step in the right direction to ensure that there is some accountability and deterrence for bad actors. From the fiscal note of this bill on page 2, you'll notice that the Secretary of State receives on average around 300 election complaints per year. We believe that 618 is a great step to kind of get these numbers down. We would ultimately hope to move to 0, but the provisions of this bill adding a civil penalty, we believe we recognize the value of that deterrence. And other than that, I thank you all for allowing me to be here today. And with that, I will return the rest of my time to this committee. Thank you.
And thanks for your testimony. Ms. Hemphill, welcome. Introduce yourself. Give us your testimony.
Thank you. My name is Sheila Hemphill with Texas Right to Know, and I have a true story that may bring a little levity to this very serious situation. In 2013, Dr. Laura Presley and I were doing some lobbying work up here. No, we were advocates, as on the smart meter situation. With her degree in physics and my degree in computer science, we really clicked. In 2015, when she tells me what she saw in her election in Austin, I'm like, oh my gosh, Laura, I'm in Austin. I need to spend the night and get to my senator and tell him what you're telling us in 2015. So I'm looking for a place to stay overnight. I normally stay with a person. She goes, sorry, it's not happening. So I'm on B&B. Don't ask me why I clicked on this room option. And it said, if you want to know more about me, you can listen to my compression drum video. So here we go. You ready? Electronic voting is corrupt. Electronic voting is corrupt on this video. I'm like, you cannot believe why I need a room, because I need to speak to a senator about what we're finding with the electronic voting system. So we finagle our way around how you're not supposed to be able to talk to each other. He goes, you've got to go to YouTube and look up Clint Curtis, entitled Uncounted Clint Curtis $1 Million Programmer in 2015 of his congressional hearing as a programmer. And oh yes, you can go and corrupt the database. When asked, would anybody be able to detect it? And he said, no, unless you had access to the code. No one would detect it. This is 2015. I'm like, this was like a slam dunk. He admitted doing it in congressional hearings. Why are we still here 10 years later, still with electronic voting systems that can still be corrupted as a programmer? You go in there, you change the database. If you don't have the paper to back it up, how are you going to prove it? So I would encourage this committee to listen to Dr. Presley and what's happening, and let's fix this, because we can, if we'll be brave enough to go against the current on electronic everything, which isn't all it's always cracked up to be. So.
Thanks for your testimony. Mr. Moore, welcome. Introduce yourself. Go ahead.
My name is Ken Moore. I'm representing myself, and I am for this bill. And I have another Harris County story to tell to back it up. I'm sorry, Senator Betancourt's not here to confirm it. 2020 election, I think it was 2020. We had local officials that ignored, again, the code and came up with their own innovations. They came up with the idea of having drive-through voting, almost like a sonic drive-through. You just go in and they pass the voting machine around, everybody in the car votes. This, of course, ignored all the hours that you were supposed to keep. This thing was open 24 hours. You had several people in the car, and so there was no privacy. And they would hand this thing around, which meant several people voted the same ballot style. Now, the way these machines work, this is the old E-slate machines. You're supposed to, after you do the voting, you reconnect it to the controller. And then that's where the votes are downloaded, and you reset it for another access code. They didn't do that. And so the votes had to be retrieved from the memory card inside the E-slate itself, not from the controller, where it normally come from. You had to, this whole thing was outdoors. You had wind blowing, you had rain blowing through there. It was an absolute nightmare for poll watchers trying to keep up with this stuff. This is what happens, though, when you have local officials go off on their own and try to invent things. It's the job of the legislature to put these things together. This is where this stuff is supposed to be crafted. In another hearing several years ago, Mike Schofield made this point, that this is how you do good legislation. You gather some evidence, you put together a draft bill, you then bring people in, various backgrounds, various expertise, and then you whittle away at it. And after you've done that, you come up with the final product, and you pass it and you sign it. That is how legislation should be done, not local officials going off on their own.
Thanks for your testimony. Mr. London, welcome. Get close to the microphone. Introduce yourself. Go ahead.
Thank you, Chairman. Hi, my name is Dennis London, and for this, I am acting as the spokesman for Grassroots America, We the People Political Action Committee. So good evening, Chairman Hughes and members of the Senate Committee. Grassroots America, We the People, strongly supports Senate Bill 618, and we'd like to thank Senator Sparks for filing this critical bill to address a long-standing and growing problem, and that is the steady erosion of legislative authority by unelected bureaucrats. The Texas Constitution, Article 1, Section 28, is pretty clear. No power of suspending laws in this state shall be exercised except by the legislature. Yet time and again, election after election, we witness unelected election administrators at all levels simply ignoring the plain language of the law and overriding legislative intent. Despite efforts by the 87th legislature to prohibit alterations to election laws unless specifically authorized in the election code, Administrative rule changes and unlawful waivers persist every single election cycle. Senate Bill 618 is needed to finally establish accountability through civil penalties and legal standing for voters to challenge these actions. Every election, Grassroots America receives reports from across Texas detailing serious violations, from counties waiving the printing of tally tapes at poll closure, to ignoring hash test failures, to obstructing poll watchers from ensuring the proper chain of custody of ballots. Each and every one of these acts violates both the law and the public trust. During the November 2024 general election, our members across multiple counties reported that poll watchers were blocked from observing the transfer and processing of ballots, a direct violation of Texas Election Code 33.0605B. And you've heard from some of those citizens and election experts today about their firsthand experiences. And as you've already heard, this unconstitutional practice of waiving election law, it's not just illegal, it's an affront to the rule of law. Texans expect and deserve consistency and integrity in our elections, and we respectfully urge you to pass this bill out of committee. I welcome any questions.
Thanks for your testimony. Members, any questions for these witnesses? Thank each one of you for being here. Thank you. You're excused. Chair calls one more time Ed Johnson, Terry Putnam. Those are the witnesses we have registered on for or against Senate Bill 618. Anyone else wishing to testify on for or against Senate Bill 618? Seeing none, public testimony is closed. Bills left pending at this time.